are various reasons why someone decides to file pro se as opposed to hiring an attorney. And so this video is going to focus on those of you that have chosen to file pro se for a family matter without the assistance of an attorney. Now again, I'm Ruby Barr and I'm a licensed attorney. This information is presented as just that. It's information and it is advisory. It does not constitute legal advice in your particular situation. It is just to give you an overview of what is required to file your own case in family law. So you've decided to file and you've obtained a packet from the local clerk of court in your county, or you've gone to floridacourts.org, FLCOURTS.org, floridacourts.org, and you've downloaded all the files, or you've downloaded and saved the files so that you can then type on the files. Now, I do want to tell you that if you buy the packet from the clerk of court here in Leon County, you can just handwrite them in. But if you download it on your own, in order to save yourself some money or some toner or some ink, don't download all of the instructions, just download the actual forms. And so whether or not you're filing a petition for dissolution of marriage, or a petition to establish paternity and other related relief, or even a modification, pretty much the forms are all the same. And so in that packet, there will be a petition. And that's the form that is used to determine who the parties are and what type of case it is. And then you will have also, and this is in no particular order, there will be a financial affidavit. Short form is if you earn less than $50,000. Long form if you earn more than $50,000. There's the notice of Social Security number. In our office, we only put in the last four numbers. I suggest that you do the same. There's also the Uniform Child Custody Jurisdiction Enforcement Act affidavit, also known as the UCCJEA. That's where the child has lived for the past 5 years, and if there are any other court actions going on concerning those children with respect to custody or child support. In some of these packets, there's a parenting plan, and you can complete the parenting plan. It's just what it is you'd like to have. You don't have to, because it's probably going to be a different arrangement. You will also see in some of these packages, especially those for divorce, you will see a marital settlement agreement. I suggest that you not complete that. Only complete that if you and the other party agree, because that's the only way it can be an agreement, and then it has to be notarized by both parties. And so again, there's the petition, there is the financial affidavit, there's the UCCJEA, there is the Social Security, and there are a couple other little forms that have to be done as well. There is a designation of your mailing address, and so you need to do that. You also need to file a copy of your driver's license or voter's registration, and the reason why is because in Florida, in order to get a divorce, you have to have lived in the state of Florida at least 6 months before you file for divorce, and that's what they use that for. If you can't afford the fee, the filing fee for the divorce or for the paternity case, you can file an application for determination of indigency. And if that is approved, then not only will the filing fee be waived, which is like between $350 and $400, depending on if it's a divorce or if it's a paternity, that's waived, but then the sheriff's fee is waived as well. Because when you file these petitions, you have to have the person served. And so that's a $40 fee, and that's waived as well. And so you also need to do a summons. A summons is telling the sheriff or the process server that this case is against a particular party, and this is where they need to be served. And it is attached to some documents that when you serve the person, provide them with a copy of the documents, putting them on notice that a legal matter has been filed against them, then it gives them information. It's letting them know, listen, you have 20 days from the date that you've been served. And that means holidays and weekends. You have 20 days, and you have to provide your original response to the court, provide a copy to the attorney or to the other party. And please always keep a copy for yourself. anything that you file with the court, keep copies for yourself. If you don't have a physical copy, then scan it and keep it in your records in cyberspace someplace. It's very, very important that you keep all of these things, okay? And so now what will happen is that once you've completed all of these forms and you submit them to the clerk of court, they will then file it and assign a case number. That's the only thing that the packet does. It gets you a case number. It gets you into court. Now the question is, well, where do we go next? What is next? Well, in Leon County, if you file your own case, you will receive an initial contact letter from the family court coordinators. They are not attorneys, but they will try to assist you in moving your case along, because whoever files the case is responsible for moving the case. Otherwise, it just sits there. And so the family coordinators, they will send you this letter and they want you to read it, and they will have these check boxes of all of the things that need to be completed and filed with the court before it can progress to the next phase. And it will tell you whether or not the petitioner needs to complete this form or whether or not the respondent needs to complete this form. Now, one thing that I will tell you, and this is really important, whether you're divorcing or whether or not you've ever been married, if you have children under 18, in this case it's about children, you have to take a co-parenting class. And so now co-parenting classes are generally online. It's a small dollar amount. They're usually $30. Now we use Florida State. It has a co-parenting class and there's no cost to that. But it's your choice, whatever parenting class that you want to use. But you take the course online. You don't have to take it all. It's like a 4-hour course. You don't have to sit there the whole 4 hours. You can take it in segments. But once it's completed, they will then give you a certificate. Download the certificate and then file it with the court. All right, so now you're moving along and you've gotten this contact letter. You're seeing what needs to be done. You're doing your part. So I can tell you that generally one or two things is going to happen. The judge is going to order that your case be referred to the magistrate. That's a type of judge, but it's designed for people who don't have attorneys, because it's more of a conversation when you're having a hearing. You know, it's not I object, Your Honor. That's hearsay. Nah, it's a version whereas, okay, these are lay people. They're handling on their own. They don't understand all the legal jargon and whatnot, and we'll work through it. And they will be more patient with you to work through it. Now, the other thing is that the judge may order you to go to mediation, because definitely if you got attorneys, it's mandatory in the state of Florida, you go to mediation. Although sometimes people waive mediation, but mediation is a really good thing because there's a trained professional that's neutral that will guide you through whatever the issues are to attempt to do a resolution. Now, you can have a full agreement in mediation, you can have a partial agreement in mediation, or no agreement. That's called an impasse. Or you can say, well, you know what? Hey, let's pause. Let's stick a pin in it and then come back. Let's see if we can work out some things and then we'll come back. And so whatever happens at that mediation, the mediator then sends a notice of filing to the clerk of court. Put in the court file that the parties attended mediation, and all it is just a report that they reached a full agreement, partial agreement, no agreement, or there was an adjournment, meaning they paused and they're going to come back. You know, they're going to come back within 30 days, and if they don't, then it's just considered no agreement. Once there's that agreement, it's still not a court order. Then it has to be, that agreement, be it full or partial, has to then be submitted to the judge and attached to what is known a court order. And so everything might be resolved. If it's not resolved fully, then it goes to the magistrate. When parties cannot agree, the judge or the magistrate will make the decision. And so families, that's really important, that, you know, you don't really want the judge to have to make decisions for your life. If it's within your power to make that decision, you make the decision yourself. Please make the decision. Remember that in the state of Florida, the standard for children is what's in the best interest of the children. So if children are involved, they're going to really consider the best interest of the children. Judges are used to bickering parents. Judges are used to parents who hate each other. But it's always refreshing when parents can come before the court and they are civil and they're able to agree, because it makes for better children, you know. And so it's really important that we understand that even though, you know, we're going through, it's a time of distress. And sometimes divorce is like a type of death, you know. It's not the family unit that it once was. But it's a new normal, and it's a different type of family. And so I think that it's really important that even though you're going through these situations, that try to remember to stay into the parameters of being family. Because at the end of the day, that's what's really important. So again, this is Ruby Barr with Southside Community Law Center, informing you so that you will know that knowledge is power and power is king.